Preparing for, I want to address a few remarks towards the attorneys that have worked so very diligently over the course of this tragic, consequential case, who work every day in the system. The defense ensuring that the constitutional protections are afforded their client, developing a relationship of trust with the defendant, doing so with professionalism and experience. The state working with law enforcement, investigating, solving the crime, remaining objective and doing it in a professional and constitutional way. All of this, by the court's observations, has been done by both sides with integrity. And I want to express my gratitude for the manner in which you have all done that. I have watched counsel over the course of this case, and particularly over the course of the last 2 days, exhibit emotions, which demonstrates the investment that you have in your cause. In this court's view, you have done this with honor. I know the hundreds of hours of preparation that have gone into this work. The defendant has been well represented. The state of Idaho has been well represented. This court will now fulfill its duties, and they are duties that I undertake with great humility. It is a weighty decision that has profound implications for many. The people that have participated in this hearing today are all wrapped up in this very somber experience, each with a perspective. The attorneys on each side and their team with many, the loved ones who have been affected by this offense and beyond. The community, and now this court enters with its role. I am guided by 4 objectives imposed upon me by the law, and they include protection of society, deterrence, rehabilitation, and punishment. I have reviewed the close to 1,000 pages of the pre-sentence investigation report, reviewed every record of the file, every exhibit, watched every video, listened to every audio recording, taken notes, listened carefully to each argument, each impact statement, and the words of the defendant. When I speak to all. There will, however, be instances that I speak directly to certain individuals, including you, Mr. Best. Please understand that the court must consider all things. The mitigation, and these, Mr. Best, are those positive and redeeming attributes of you. I must also consider those things that are not. We call this aggravation. This court is the neutral. Much has been highlighted and can be placed in these 2 categories. And I will speak to both and highlight the things that I've heard over the last couple of days and the things that I have found to be noteworthy in my preparation. The defendant very effectively demonstrated in this case mitigation. It exists, and the state very effectively demonstrates aggravation, and it exists. I will begin with mitigation. Mr. Best, you have talents. Running your business takes skill. It appears that you did quite well at that and had a knack for automobiles and an understanding of engines and repair. I reviewed school and business records. You worked your way through school, including educating yourself in a trade. You contributed to the community and provided a service to many patrons. Callie was a stabilizing influence in your life. In any sentencing, and this one in particular, there are things that touch the court. Little facts or points of interest or information that bring a human side to these kinds of tragic events. And I share a few of these from my notes in the context of mitigation and aggravation. Mitigation of a time prior to the effects of your actions, and aggravation as a reminder of what was taken, what was lost. One such that I think affected most in the courtroom today were those handwritten notes found in your home from her expressing encouragement and affection towards you. Physical and mental health clearly began to deteriorate, and work and the stress and the toll it had upon you had an effect. On top of that, it's clear that you suffered back pain. Automotive labor had its toll on your body. Neck and back pain arrived. Chronic pain was difficult. Opiate use for some time. You got off those and turned to cannabis as a substitute. This was difficult and affected other aspects of your life, like sleep. Under the stress, pain, and lack of sleep, and what the court perceived as personal difficulty and crisis, for a period of time you turned to other substances. And psychotic features arrived. This court notes from others and those around you, there began to be concern, and many would say that you were not yourself. As you examine your actions and others examine your actions, I highlight that you were not yourself. And that was manifested by your speech, disorganization, and paranoia. After being released from the hospital, following the crisis in Swan Valley, you were released to the care of Callie. Such another poignant observation. You have been stable in custody, and the jail generally reports of you being polite and responsive. I want to thank you for your cooperation with Dr. Landers. Your cooperation provided the court with professional insight and expertise into you, who you were, who you are, and who you might become. While you did not submit to other experts, however, that was your prerogative. You suffered and continue to a degree the mental health challenges, including ADHD, insomnia, and physical pain. You were introduced into the criminal justice system with DUIs some convictions years ago, but largely you were free from a pattern of criminal interactions with the law. And this is mitigation as considered by the court. Callie knew you and that you needed help. She intimately knew that. Others around you knew that you needed help. And I am convinced that you knew you needed help. I concluded from the materials that you sought help. It wasn't all lawful, but I believe you sought help. This includes help for the physical ailments, mental and emotional difficulties, substance addiction issues, attending the Walker Center in 2003, and you had a significant period of sobriety. You self-medicated in some respects to manage the disruptions your difficulties were causing. And this is often dangerous, but understood by the court. Pain, physical and mental and emotional, make life more difficult. Things began to spiral in a more negative direction, and perhaps the stressors increased, including marital difficulties. You demonstrated poor insight and notably not taking medications. You destabilized psychiatrically and behaviorally. Yet, the court sees an effort from you. And of course, very tenderly and demonstrably from your wife, Callie, to address these issues and assist you in confronting them. I think it was from the video that was watched that one of the most poignant moments in these 2 days was her statement of not leaving and her commitment to see things through. Once stabilized, you behaved properly in custody, and I've watched with a careful eye your demeanor in court over these many proceedings, and it has always been appropriate, and I appreciate that. I have the impression that you cooperated with your attorneys. I also watched very carefully over the course of these 2 days you and your reaction to the things that were being presented, the things that you were being exposed to. I noted Mr. Meekham's testimony, how being introduced or reintroduced to perhaps meetings with counsel or discovery that was being provided undoubtedly had an impact upon you. That tells the court that you are an emotional person, one who is sensitive in some respects. And I saw over the course of this proceeding, during the state's presentation, photographs when that had an emotional reaction to you, but none so powerfully as today when you saw the photographs that you presented and those notes. Also, for the court's consideration of mitigation is the plea itself. This was a negotiated agreement with the seasoned experience of Judge Schinderling. I presided over the change of plea, and I saw it even in Judge Schinderling's demeanor and face, my perceptions of what the parties went through to reach an agreement. Each side conceding significant interests for the state and for the defense, potential life, your life, for punishment. And so for the defendant to willfully, voluntarily enter a plea to take responsibility, that is mitigation. The court reviewed the number of letters on your behalf. And it's clear that there are a number of people that are fond of you. In fact, this afternoon, the testimony of Mr. Max, actually it was Josh Lord, lost a friend by a friend, and the impact that had on him. Mr. Best, as the court pronounces sentence in a moment, might I encourage you to be vigilant in attending to those who will have the responsibility to assist you in caring for your mental health. Be medication compliant. Take advantage of the programs that better you. Increase education of all kinds, and be a good inmate. You will be a member of a new community. Even in custody, you have every day internal choices to your response to the things that are expected of you, assignments and requirements. While you have lost your liberty, one thing that this court cannot take from you is your ability to make choices within the confines of your environment. May you choose well, and as your counsel, who very emotionally and passionately suggest to the court, I pass back to you to find hope. Now the court will discuss the aggravation of your offense, and this can only be viewed from a point of view of evil and horror. Your acts cast a shadow, a darkness over so many. And for some, it might say, as we heard in the impact statements today, more than a shadow, but taken nearly all light from the lives of many. There are those who were close to your victims, and of them, you took everything. The court a moment ago indicated that it was the neutral. And I want to restate that again as I share a few thoughts about what I heard from those making an impact statement and address the yellow ribbons in the courtroom. So, ladies and gentlemen, those of you that are wearing those yellow ribbons, please understand that the court recognizes purpose of them and the solidarity and support that you have to wear them. Had this been in front of a jury under very clear authority, the court would not have permitted you to display those on your lapels the way you have today. It was brought to the court's attention, and Mr. Archibald was considerate, and I must say for the record that the court is the neutral, and the yellow ribbons have no impact upon the court's sentence. But I do want to respond to the things that I heard those of you say today. And first, I will say the kind of courage that it took to come to the lectern and open your heart and share the things that you did. You were composed with grace, and each statement was very appropriate. To Mr. Best's mother, who knows you better than anyone in this courtroom, is in fact a victim of this offense, and that was clear in her remarks. She expresses her love to you and to those that are lost. The other victims to the father, there's a word that was used throughout the statements that I highlight because I think it is so applicable, and it's the use of the word haunt. Mr. Best's actions haunt others. I quote, "I will live out my life in grief and pain." The brother also used the word haunt. You know, the use of that word conjures a revisiting of anguish and pain. I was struck by his language that I am not the same man, that person is gone. That your actions didn't just take lives, but shattered futures. To the mother, indications of suffering every day, and the loss unbearable. And of course, the sister. This court has presided over 2 to 3 dozen homicides, and I do not believe I have felt closer in terms of a description of a person than with Callie. So I thank you for that. It was clear that she was a special person with many wonderful qualities. The state makes the argument about the impact that this has had on the community. This court has presided over cases in Teton County for 15 years. I recognize this community as a special one. It is small, it is tight. I was struck by the body camera video that provides the best representation of things as they were, and in watching the footage of the responding officer and hearing and seeing the spontaneous reaction to the discovery of Callie. It demonstrates how many lives are affected by this crime. As he sees her, illuminated by the flashlight, darkness everywhere beyond the light, he reacts in horror, frantically adjusts her, attempts CPR, and then says, "She is gone," over his radio. You can hear the change in his breathing as he discovers her. And she is gone. Gone to those that knew her, gone to those that needed her, gone to those that didn't know her, but are affected, and gone, Mr. Best, by your hand. Your single act creates a chain reaction of consequences. And as the state argued, spreading outwardly like ripples in a pond, ripples spreading outward. And so it is with the consequences of your act. Anyone touched by this offense will have the dark clouds present in their lives and in the memory forever. A neighbor who heard the yelling and then the shots, that same neighbor stated that in an earlier instance, you were berating her. Each victim of this offense deserves a statement from the court. And I shrink at measuring what the court would say about each and the adequacy of my words. Callie, I would say, Mr. Best, she loved you. She expressed that even in the moments before you ended her life. She expressed that. With shots from the firearm, her death came quickly. Gunshot wounds, bleeding out, and an immeasurable loss to so many. Zeke, like the state, I believe, suffered the most. Being taken by his father in the night, being awakened, placed in a car, driven around with a dad he probably did not even recognize, given your state of mind, while his death might have arrived quickly. I believe his fear would have felt to him eternal. Ken Martin's testimony persuading the court that there were shots, of which one, perhaps two, occurred while she was down in an execution type killing. The court was persuaded through the state's presentation that there was a struggle. And the unborn child, Freya, reviewing the photographs, an unborn fetus still attached to a placenta and an umbilical cord. When a tree dies, so does every leaf. When you took the mother's life, you took hers. Her life was over before it began. And from what I could see, a perfect little body whose heart stopped when her mother stopped. I know a human's life has greater value than a dog. I don't even mean to measure or equate the two. Yet, pets play a meaningful role in the lives of so many, and you took that life as well. This court understands that all too often, perpetrators of domestic violence and the infliction of harm to family pets, this is a tragedy independently. There is argument this afternoon regarding premeditation. The court turns to the information in lieu of an indictment. Count 1, murder in the second degree with malice and a forethought. Count 2, murder in the second degree with malice and a forethought. And count 3, murder in the first degree, the taking of the life of a child under the age of 12. So while counsel may argue the state and the defense about the premeditation, the element that this court places its attention on is malice and a forethought. As the court reads these counts separately, it's understood that each is a loss of life. And with that, there is compounding wrongdoing, compounding loss, and compounding need for punishment. The court wonders, what if, after killing Callie, you would have ended the tragedy, fled, absconded successfully, turned yourself in? But that's not where it ended. After careful consideration, I am persuaded that there are some offenses that deserve the maximum penalty allowable under the law. For this court, it is fixed life in prison, and these offenses require the maximum penalty. A fixed life sentence without parole. As such, the court sentences the defendant on count 1 of second-degree murder to a fixed life, a $50,000 fine, and a $5,000 compensatory fine. Count 2, murder in the second degree, Zeke Best, fixed life, a $50,000 fine, and a $5,000 compensatory fine. Count 3, the unborn life, murder in the first degree, fixed life, a $50,000 fine, and a $5,000 compensatory fine. These counts will run consecutive to one another. Mr. Best, you have the right to appeal this judgment within 42 days. Post-conviction relief expires a year after that, and a Rule 35 expires in 120 days. Mr. Archibald will visit with you about whether any of those remedies have any applicability. Thank you once again.
Judge, there was just one
Restitution.
correction. On count 2 and count 3, the victims were reversed.
I'm sorry.
The victims were reversed. So
Count
2 was Freya.
Count 2.
Was Freya, and count 3 was.
Court's looking at substitute in lieu of indictment. Count 1, murder in the second degree. Count 2, murder in the second degree.
That was correct.
And then count 3, murder in the first degree of the child. Thank you. Okay. The court had just transposed to our victims instead. Thank you. I didn't make any comments about restitution, nor did I hear any. Is that something that will just be left open, or does the state have an interest in pursuing any restitution?
The state requests 30 days to file. I don't expect that it will take us 30 days. It probably will take a few, but we request 30 to file.
Thank you. That would be granted. Mr. Archibald, do you have any questions or anything further? All right. As I was concluding, thank you again to all that participated. This court is in recess.
All right.